Hey everybody, I am Surbhi and you are watching Key Differences. Today in this video, we are going to talk about the differences between Memorandum of Association and Articles of Association. So friends, what are we waiting for? Let's get started. Memorandum of Association (MOA). Memorandum of Association is the basic document, or we can say the first important document required to be originally created by every company and filed with the registrar at the time of its incorporation. Basically, it lays down the company's constitution and is the foundation upon which the company's structure relies. It states the powers and objects of the company and the scope of its operations beyond which the company is not permitted to act. Now you guys must be having a question in mind, why an MOA is created? Well, it is prepared to enable shareholders, creditors and all the outside parties who deal with the company to get an idea about its powers and scope of its activities. Investors will get to know about how their investment is going to be utilized and the risk involved in that. So memorandum provides information about the company as to its name, registered office, objects, capital and limits of liabilities. It is signed by the subscribers who are the first members of the company at the time of its registration. Objects given in the memorandum state the scope of its activities, area of operation and limit of the power beyond which the company is not allowed to act. It contains the fundamental conditions upon which the company is incorporated and it determines and regulates the relationship of the company with the external parties. That is why it is also called as Charter of the Company. On registration of the company, memorandum becomes a public document, which means that any person can inspect it. So here it is to be noted that every person who deals with the company is presumed to have adequate knowledge of its contents. Moving on with the clauses of memorandum, there are 6 clauses in a memorandum of association. The first one is name clause. Name clause contains the name of the proposed entity. Being an artificial legal person, it gives the company an identity and is a symbol of existence. There are certain points which should be considered before deciding the name, like it should not be undesirable, also it should not be identical with any other company's name, and it should end with the words limited or private limited as the case may be. Next is location clause. Another name of this clause is registered office clause. In this clause, the state in which the registered office of the company is located is specified. Here one should note that an applicant can file with the registrar the information about the correspondence address till its registered office is set up. Further, the same shall be filed with the registrar within whose jurisdiction the registered office of the company is proposed to be situated. Also, a company is required to furnish the registrar the verification of its registered office within 30 days of its registration. Next is object clause. It is the most important clause of the memorandum. It contains the object for which the proposed company is set up. It also contains any matter considered relevant in furtherance of these objects. Here a point is to be noted that a company is allowed to pursue the objects stated in the object clause of the memorandum, and any act beyond that is considered ultra vires the company and hence considered as void. Next is liability clause. Liability clause of memorandum states the nature and extent of liability of its members. So, when a company is limited by shares, the liability of its members is limited to the amount unpaid on shares held by them. Whereas, when a company is limited by guarantee, the liability of its members is limited to the amount which every member undertakes to contribute to the company's assets in the event of winding up of the company. Further, in case of a company limited by guarantee having share capital, the liability of members include the liability for guaranteed contribution in the event of winding up of the company along with the unpaid amount of shares held by them. Lastly, in case of an unlimited company, the liability of its members is also unlimited. Next is capital clause. Capital clause states the amount of capital with which the company is to be registered, that is the authorized capital. Authorized capital is basically the maximum capital which a company can raise during its lifetime. Capital clause also contains the division of such capital into shares of a certain amount. Lastly, subscription clause. The company's memorandum needs to be subscribed by at least 7 people in case of a public company and by 2 people in case of a private company. Coming to the forms of memorandum, Memorandum of Association must be in a prescribed format. The prescribed forms which are given in Schedule 1 of the Companies Act are Form in Table A for company limited by shares, Table B for company limited by guarantee, and not having share capital. Table C for company limited by guarantee and having share capital. Table D for an unlimited company not having share capital. Table E for an unlimited company having share capital. Now moving on to Articles of Association. Articles of Association is the second important document which should be filed with the registrar at the time of its incorporation. Basically, it contains the rules and guidelines for the governance of the company. Here you should note that the Articles of Association is subordinate to and controlled by the Memorandum of Association of the company. And therefore, while framing the Articles of Association, it must be kept in mind that they should not go beyond the powers of the company given by memorandum. Also, such rules must not be contrary to the provisions of the Companies Act. Its contents include name of the company, name of the state in which the registered office is located, interpretations of words or expressions used in the articles, share capital, rights attached to different classes of the shares and variation of such rights, lien on shares, call on shares, transfer and transmission of shares, and many more. Therefore, Articles of Association is a document which contains the rules, regulations, and bylaws which are helpful in the administration of the company's internal affairs. These regulations determine and regulates the mode and form in which the management of internal affairs of the company is carried out. Also, it outlines the powers and duties of the directors and officers of the company. Moreover, it acts as a basis of contract between the company and its members and between two or more members of the same company. Here you should also note that the Companies Act contains several provisions under which the company can act only if it is authorized by its articles. Now coming to forms of Articles of Association. The forms of Articles of Association are given in Table F to J in the Schedule 1 of the Companies Act, wherein Table F is for the company limited by shares, Table G is for company limited by guarantee and have share capital, Table H is for the company limited by guarantee and not having share capital, Table I is for unlimited company having share capital, and Table J is for the unlimited company not having share capital. Moving on to the difference between Memorandum of Association and Articles of Association. So friends, we have learned that Memorandum of Association is the fundamental document comprising of the relevant information about the company which is required at the time of its incorporation. On the other hand, Articles of Association is the supplementary document which contains the rules and regulations made by the company for its own governance and day-to-day management. Along with that, it also contains information about the accounts and audit of the company. Next, Memorandum of Association is the constitution or charter of the company. It is the source of company's powers and authority. Here you should note that the company's Memorandum of Association does not state the powers, but it empowers the company to do whatever is within its scope. As against, Articles of Association are the regulations for internal management of the company. Type of information contained. Memorandum of Association states the objects for which the company has been formed, whereas the Articles of Association provides the manner in which the company's objects are to be achieved. Next, while Memorandum of Association is subordinate to the Companies Act, Articles of Association is subordinate to the Memorandum of Association of the company. Next, every company, whether it is public company or private company, is required to frame the original Memorandum of Association for the purpose of its incorporation. On the other hand, only a private limited company is required to frame its articles, while the other companies can opt for model articles specified in Table F to J of Schedule 1 of the Companies Act. Next, to make alterations in Memorandum of Association, special resolution needs to be passed at an AGM, that is Annual General Meeting of the company. Further, there are many cases when prior approval of central government is required for making alterations in Memorandum of Association of the company. Oppositely, Articles of Association can be altered by passing a special resolution at the AGM. However, approval from central government is required in case of conversion of public company into a private company. Next, talking about the retrospective effect, Memorandum of Association of a company cannot be amended retrospectively, whereas Articles of Association can be amended retrospectively. Relations. While Memorandum of Association defines the relationship of the company with the outsiders, on the other hand, Articles of Association defines the relationship between the company and its members and also between the members themselves. Now, have you ever wondered that what happens if the company performs an act which is beyond its scope? Now, if the act performed is beyond the scope of memorandum, then the act is considered as void and has no legal or binding effect. As against, if the act is beyond the scope of articles, then it can be ratified by the members. Ratification means to make something valid officially. So ratification of that act is possible only when the act is within the scope of the Memorandum of Association of the company. Otherwise, it cannot be ratified. So guys, this brings me to the end of this lesson. I hope the concepts has been cleared now. However, if you want to study the topic further in detail, you can visit our official website, that is keydifferences.com. Here you can find a detailed comparison of memorandum and articles of association along with their definitions. Links are also provided in the description box below. I hope you liked this video, and if you did, please do give it a thumbs up and share it with other people. Also, if you are new to this channel and wanna get more such useful videos, consider subscribing this channel and also hit the notification bell next to the subscribe button so that you are notified every time a new video is uploaded on this channel. And if you have any queries or feedback for me, then feel free to leave in the comment section below. Until next time, this is me, Surbhi, signing off.